Hello, 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 hello. It's almost 6 p.m., 2 minutes to go. I am going to go ahead and get started. We're going to go quick. So basically, just waiting for one person to get in. We're going to go quick because it's Thursday. We're already tired for the week. And 6 p.m., it's kind of like late almost. Anyway, we wanted people to get here. Those who have jobs, to have some time to get here. So yes, 6 people, come on, let's get started. Let me open up the chat. Hello, Cynthia Owen. Hi, what's going on? Let's get started. So we have 3 topics, okay? Prosecutorial discretion, cases reopening, Chavez v. Garland. So what's going on? Okay, so with prosecutorial discretion, I've already talked about it. So basically, the power of the government to drop the case, no longer pursuing a case. That's something that if somebody's interested in, they can talk to the lawyer and see how they can get the government to drop their case. But the thing is, if you drop a case, it looks like you must have an alternative solution as to perhaps cancellation of removal, adjustment of status. You have other venues. That's why you're dropping the case. So then we have cases reopening on the departure bar. So basically, it's saying that, well, once you leave the country, the law used to be that you can't come back and reopen the case. So now it's saying that, well, the judge can, in fact, reopen their case. Sua ponte simply means that on their own. So, and then we have Chavez v. Garland, where the notice to appear was defective, lacking the time, the date, and the place of the hearing. And then Chavez argued that, well, I've been living here for 10 years continuously because my notice to appear was defective. And then the Supreme Court has ruled that with a notice to appear that is defective, then they can count the day and the years even after the notice was given. So that's why Chavez was able to pursue cancellation of removal. And then some people can also pursue cancellation of removal under that Chavez v. Garland. So that's what's going on. Okay. So if you have questions, let's get into it. Questions, let's get into it because we are going to go really fast today. I just want to get questions. If you have questions, let's get into it. 17 people, nobody has questions? Hello, Olayinka. Hello, Igidi. I guess I said it right. So, hi. Nobody has a question? Well, then we're gonna end. So let's get into those questions quickly. Maybe tomorrow I'll do it at 10 a.m. because it looks like 6 p.m. I wanted to do that at 6 p.m. because I was like concerned about people who actually have late jobs. So, okay, Zia has a question. How much it takes to have a work permit for applicant for U visa? Well, it used to take up to 4 years. Basically, it used to take like the application has to be approved first. But now they say that once they determine that the case is valid, prima facie, they determine that the case is valid, then they can issue the work permit, which means that might not be taking longer anymore. Maybe 6 months, 7 months, they'll issue a work permit. What is the latest news about immigration? Well, the latest news is the one that we're waiting, the one that I talked about yesterday about, whose name is that person? Bernie Sanders, talking about that they are going to try their best to put the infrastructure basically insert the immigration bill into the infrastructure bill. We're just gonna wait until September to know. So even if you live there 9 years, it doesn't apply. Bolton, what is the beginning of the question? So even if you live there 9 years, it doesn't apply. What do you mean? I don't know the beginning of the question. How do you go about doing an expedite request for your family? Oh, Alan, let me find it. Let me show you how to do an expedited. Alan George, let me show you how to do an expedited request. You just share my screen. Share my screen for a little bit. Okay. If you go on Google, you just put expedited request, USCIS. Yep, you go to the web page, it tells you how to make an expedited request. Let me copy this link. Really, it tells you everything on how to make an expedited request. Okay, stop sharing. Let me go back. I copied the link. Well, that's the link for you, Alan George. What about DV Lottery 2021? So basically what they're saying is like there's a lawsuit, I guess, going on. Basically, they're trying to ask the government to issue visa. So the Department of State has to compel the embassy to issue visa. I don't know where it stands currently, but that's what's going on. And not a lawsuit, I believe. The last time I asked about a waiver, what qualified me for one? Overstay my visa for 2 years now. My workplace is ready to petition for me. I'm a caregiver. Yes, waiver. In order to apply for a waiver, you have to have a qualifying relative, meaning that you have a immediate family member, a spouse, a child, or a parent that could be either a lawful permanent resident or a U.S. citizen, then prove extreme hardship. So 2 things, qualifying relative, then prove extreme hardship. So I've talked about waiver. You can go Ajibade. You can go to my previous video for waiver and really just go ahead and watch those. I talk about waivers a lot. Anna, hi, I'm a caregiver. Can I apply as an essential worker? Yes. If the essential worker bill passes, yes, you can apply because you're a caregiver. As long as you work during the pandemic, that's the key word, working during the pandemic. So then the answer will be yes. People, let's go with questions. What is the option? I have been here since 2016. What option I have to adjust my status here in the USA? Well, in order to adjust status, Babalola, well, first you have to have a basis for it. Family petition. If you're not married, you marry a U.S. citizen or lawful permanent resident. That's how you adjust status. Or you have an employer trying to sponsor you. That's how you adjust status. Unless those bill passes, then you can adjust on your own. Or if you have what they call extraordinary ability, you can adjust status on your own. But again, if you overstay the visa, then it's going to require you to go outside and then come back. Can siblings? No, siblings is not Ajibade. Siblings is not qualifying relative. When they talk about qualifying relative in the context of a waiver, there's only immediate family member, which is spouse, child, and parent. 3, that's it. Anna, thank you very much. You're welcome, Anna. Can you open your case after letting it into default by not showing up at the court because you were scared of Trump and his agent? Well, if you, Tom Ngwanda, failure to appear in court, you have a ban for 5 years. Oh, not a ban, a bar. Almost the same thing. failure to appear in court, you have a 5 years ban, bar. So basically, you can't do anything until the 5 years has passed. Then you ask to open a case, and eventually you have to have a waiver so they can forgive you for why you didn't appear. So that's exactly what you should do. First of all, it's a 5 years ban, failure to appear in court. You have to have a reason as to why you failed to appear. But if you fail to appear in court without a reason, so you are giving a 5 years ban, prohibited to do anything. You cannot adjust status, you cannot do anything at all. Until the 5 years has passed, then you can ask the court if they can reopen your case, and up to them to decide now. Ajibade, I've been here for 4 years. I worked through the pandemic. Can I apply for amnesty? Yes, if it passes, Ajibade, my friends, if it passes, everybody's gonna apply. So yes, ma'am. If it passes, I don't know if you're ma'am or what, but anyway, if the bill passes, you're gonna apply. You're going to get it because you're a caregiver. Saibi, Jibril. Hello, how are you? I'm good. Jibril, what is your question? Do you have a question for me? You're welcome, Ajibadi. You're welcome. Do you have a question for me? Jibril, do you have a question? Yeah, we put it at 6 p.m. because we thought we'll have a lot of people. Because some people are working, then we say, well, let's put this live today at 6 p.m. So if it looks like it, maybe tomorrow I'm just gonna do 10 a.m. I'm just gonna see how we end up. If nobody has questions, you have a question, Jibril, then ask your question. I'm waiting. So Jibril, just a recap, we have been talking about prosecutorial discretion, case reopening, and the Chavez v. Garland, basically defective notice to appear. So those are the subjects that we've been talking about. But you can ask your question in any topic. Immigration, of course, related. So I'm waiting. Let me drink water since I'm waiting. How can I prove I worked during the pandemic because I was not paid into the account? Well, if you're not paid into the account, maybe you can ask your employer to write something that you work for them during the pandemic. Jibril, I don't think you have a question. You're just playing around. Because if you had a question, you could have just asked it instead of saying wait. So you worked, Luna Brown. You worked during the pandemic? Luna Brown. Let's see what Luna Brown said. Luna Brown, what is your question? Oh, I have a question. Yvonne, I have a question. If I come in the US 18 legally and then 24 become illegal, can I be a DACA recipient? No, DACA recipient is basically people who came under the age of 18. But you can be qualified if the DREAM Act passes. Because the new version of the DREAM Act says that 18 or younger. So, but not under DACA. Jewel Maka. Hello, always watching from Jamaica. Yes, hi Jamaica in the house. Can my daughter file? Your daughter can file if she's 21 years old and working and US citizen. So Luna, basically your daughter, if she's a US citizen, 21 years old, well, 21 years or are, and then working. Yvonne, one more question. Yes, go ahead. We're here for those questions. Waiver for misrepresentation and fraud. So yes, who's Luna, who's wanna do the waiver for misrepresentations? You or your daughter? Your daughter can claim you as a qualifying relative, but however, you can claim your daughter only if she's under 18. Reunification of family, I haven't heard anything, Jibril. I haven't heard anything moving. Since they introduced it, I haven't heard anything moving in that direction. So I don't think this year. This year, what they're really trying to focus is come up with one thing that might help some people, pretty much essential worker, basically. What are the documents needed for the adjustment of status to the Essential Worker Act? Well, to the Essential Worker Act, first of all, you have to prove, Baba Bola, that you are an essential worker. So proof of job that you work during the pandemic. So basically your job, your contract, your IDs, that's it, really. You have to prove that you actually worked during the pandemic. So basically, proof of that you work and you got paid. So basically those are the proof, like your pay stub, job description, so the contract that you had for the job. I've been here on a different visa. What, Ivan, what type of visa? Jibril says sorry. Well, Jibril, Reunification Act, really, we just have to wait for next year, because this year, really, they're just trying to get at least one thing, because the parliamentarian said that they can allow one thing. So the Democrat, they're trying to come up with one thing only, and they're trying to see how it's going to fit at least some people. Or you came with J1 visa, the exchange, B1, B2. And what was the first question? Yvonne, let me see one more question. Let me see your first question. Yeah, it doesn't matter how you came, Yvonne. The real question when it comes to DACA is if you came under the age of 18. That's when somebody qualified for DACA. And then the people who have, there's a lot of requirements. First of all, the age requirement under the age of 18. Then there's another requirement if you got here, I guess, before 2007, by the time we got in 2017. Anyway, there are a lot of requirements when it comes to DACA. The age requirement is like number one, then you have other requirements. But if you're talking about the DREAM Act, then you qualify if it passes. It doesn't matter when you move, but if the DREAM Act passes, the current version, then Ivan, you'll be qualified. Bolton, cancellation of removal. What about it? The first thing about cancellation of removal, Bolton, is that, well, you must have been here continuously for 10 years. And then the 10 years period is basically before you receive the notice to appear. Then on top of it, you have to prove extreme hardship and unusual hardship, which means that you have to have qualifying relative. So, no, I'm actually located in DC, Washington, DC. That's where I'm based. Like, that's where I work. Most of my life I spent in the US. Yeah, the qualification is basically, Ivan, is basically for DACA under the age of 18. So, but for DREAM Act, then you'll be qualified. So, let's keep moving, people. Questions, questions, questions. If there's no more question, I'm stopping at 26:20, because it's I don't think your Luna, the waiver is not that your daughter is going to file for you. The waiver is you filing for a waiver, but you have to have a qualifying relative. If you have a daughter that is under the age of 21, then she becomes a qualifying relative for you. That's what I'm saying. That's how waiver works. Jibril, can you check my case? How can I check your case? Jibril, if you need a consultation, email me. You already know I charge for consultation. Okay, thank you. Thank you, Luna. Waiver basically is you asking for forgiveness. So in order to obtain that forgiveness, then you have to show extreme hardship and you have to have a qualifying relative. So those are the conditions of waiver. So you asked to open your case. Bolton, where are you coming with that question? Ngwanda, it's me again. It has been 5 years since I missed a court hearing and I'm currently married to a citizen. Will I be better to open my old case or apply for married citizen? Well, you are going to apply for, the best way to go with it is to apply for U.S. citizenship, right? You file first the I-130, and then once the I-130 get approved, you can file it simultaneously. But now the problem becomes, are you the I-130, of course, it's going to get approved because that's the easiest part. But now the question when it comes to I-485 to get approved, that's when they're gonna bring you back to why you failed to appear because you become inadmissible. So in order for that, the entire petition to work, then you have to have the I-130, the I-485, and the waiver to ask for forgiveness for the fact that you didn't show up at the court, because it's always going to come back to you. My asylum case has been granted since February, and DHS made appeal and do nothing until now. Can I? Oh, your asylum was granted, and if since February, not and then the DHS has made an appeal. And then what was the result of the appeal? In any case, once your asylum case gets granted, there's really nothing much you can do because you have to wait for 1 year in order for you to be eligible to apply for a green card. So either way, February, you still have until February of next year. So in the meantime, you wait what the DHS is going to say on appeal. How do I bring my son who is above 21 after getting the Essential Act? Well, you just file. So basically, you're going to file. But remember, the son who's 21 is going to take like 10 years, the minimum for the son to get here. Jibril, consultation fee is 175. You know that. You already know that, but you keep asking. Consultation fees 175. Okay. Tom Monster, thank you very much. You're welcome. If a person live here 7 years and can after 3 years, so totally it's gonna be 10. No criminal record, but never pay taxes. Ivan, what do you mean by ask for amnesty? Cancellation of removal apply only to people who find themselves in removal proceedings. You can't just ask for amnesty unless there's a law that passes that allow you to just get your document. They allow that person, of course, to get the document. But if you're referring to cancel the removal because of continuous residency in America, it doesn't work like that. The person must have been in removal proceeding, and then the 10 years is counted before the person received the notice to appear, unless the notice to appear was defective, according to Chavez v. Garland. So, yeah, there's no such like applying for amnesty on your own, no. It means I need to make some reason to go in court. Don't be making a bad reason to go in court, because No, that's not, this advice is not coming from me. Don't be making bad reason to go to court. People find themselves in court, if, let's say, they apply for asylum, and then at the USCIS office, it didn't work out. Then finally, the case gets referred to an immigration judge, or maybe they got apprehended by ICE, and then ICE send them in detention and find themselves in removal proceeding. Or maybe they filed for a petition for marriage, the marriage didn't work, now they find themselves in removal proceedings, or for other crimes. So you can't just go to court like, yeah, because I need a notice to appear. No, Yvonne is so funny. No way, they're not going to give it to you, because they know people do that. They really know. So that's why that law says 10 years before receiving the notice to appear, because they know that people will just go to court because they're going to count the 10. Oh, I've been here for 10 years, just give me my paper. No, it doesn't work like that. And 10 years is only one requirement. The person has to prove extreme hardship too. So basically the person has to have a qualifying relative, and then on top of it, non-criminal record. So there are a lot of requirements to it. Okay, so if someone is undocumented, can the children come into the student visa? Will they impacted by the status of the parent? No. Immigration looks at everybody's case individually. Let's say the children comes as student, right? The children come as with a student visa. The only concern is to respect their student, or the terms of their student visa. The only concern is to not violate the terms of the student visa. I guess tomorrow I'm going to talk a lot about student visa, because a lot of people have been violating their student visa, which is not good. So to answer your question is yes, your children can come as a student, but now the question will be, are they going to get a visa? Because they'll look at their parent on asylum case. So that could be like a something, but it's not like they're not going to be impacted by that. The judge has granted this since February of 2020. So for 1 year has already passed, do nothing after his appeal. Please, can I apply for a green card? If 1 year has already passed, then you should apply for a green card, because you can't just wait for them to, they went on appeal, but they have to give you a decision. If they don't give you a decision, how are you going to know? It looks like they didn't give you timely decision, because they have to come with a decision within 6 months. So basically, you should apply and tell, if they deny you, you say, well, but they went on appeal, they never gave me a decision. It has been more than 6 months. So I have to apply for my green card. So Nathan, I think you should apply and see where it leads you. Yes, in kicking with share wheel, you have to have immediate family member. The only exception is basically if the person is claiming VAWA, like let's say the person was married to a U.S. citizen or lawful permanent resident, and then they got really like abused, then they can apply on their own without a qualifying relative. That's the only exception they have when it comes to cancellation of removal. Maxo Luma, I'm there. Yes, Maxo, what is your question? Come on, bring it. Bring your question. We've been waiting for questions. It's like almost 6:30. Bring your questions so we can wrap it up. If you had DACA under President Obama and you didn't renew it when Trump was in office and you just tried to apply again, they deny it. I said, and say, I need a lawyer. What can I do? They told you that you need a lawyer. They told you themselves that you need a lawyer. Marlene Flowers. I mean, if they tell, well, maybe the reason they're telling you that because a lawyer can make an argument for you. So I strongly suggest you consult with one to know what, in that case, what you can do. Do you undertake student visa? Not as much as asylum, removal, and all that. Not as much as that. I do take student visa where they already violated their student visa. Now they want to apply for waiver and so forth. So that's the answer to that. Elizabeth, hi Elizabeth. Please tell me if the Johannesburg U.S. Embassy will start scheduling the F-21 visa interviews. Elizabeth, that one I wouldn't know on top of my head. So basically what you have to do is just call the embassy. Yeah, some embassy have resumed work. You're just gonna have to call the embassy and find out. Max Luma, you called me back about the TPS. Ask your question here. If you call, you know you have to pay for consultation. So if you have a question, ask it here. You're welcome, Elizabeth. Questions, please. It's almost 6:30. We're gonna have to wrap it up. Maybe tomorrow we're just gonna do 10 a.m. or we're just gonna keep it at 6 because we already said 6. So maybe some people will join us tomorrow. Okay, thank you very much for coming. I don't think anybody else want to join us. This was nice. Tomorrow I'll be back again 6 p.m. Eastern time. And tomorrow will be our last session live. So we might have some more session next time. I don't know when, but I wanted to give really a full week and give people the opportunity on my channel to really answer those questions. And I think I've done it. So really, thank you for coming. Thank you very much. Tomorrow is our last session. I hope we will have more sessions like that, but this one was really like the full year, the full week, so that we can actually answer your questions. Okay. Tomorrow again, I'll be here as the last day of live questions like that. Bring your questions, bring your friends' questions, family member questions, 6 p.m. Eastern time. I'll be here tomorrow again, 6 p.m. Eastern time. Yvonne said, thank you very much. Thank you. I do appreciate your time too, coming here for this live session. Okay. Thank you very much. There's no more question. I think we are going to end today. And I hope you have a great evening. It's 6:30. We did almost 33 minutes, which is pretty good. Can you do something to me in the appeal court in Miami to dismiss the appeal of DHS? Well, of course, it is something we can do. But the thing is, if DHS hasn't responded for more than 6 months, it pretty much looks like they're not going to respond. So if you want to have a consultation outside of this place, then you're going to have to email me. I'll let you know what we can do in that case. But in my personal opinion, I think that if DHS hasn't come up with, well, basically DHS has appealed, but the BA hasn't responded to the appeal. And the BA usually take 6 months, but now they're taking forever. Maybe you should try to send them a motion to tell them like, well, you need to respond on this appeal because I'm getting ready to apply for my green card because a year has passed already. So that's another option. Okay. So thank you very much, and I'll talk to you later. Bye-bye. Nathan, if you need more explanation, then you're gonna have to make a consultation, okay? But as far as I'm concerned, you can really just like apply for the green card and let them know that the appeal it has been more than 6 months. It's not timely. So you can't just wait there in case they reject that green card application. So anything about Dream Act? When do we know? Nothing. We're just waiting for one thing in September. One thing. They said they're gonna come up with a bill in September, so we're just waiting for that. I did asylum. I want to apply for TPS. It's my first case. Oh, don't close your asylum case. I really strongly advise not to close the asylum case. That's my advice. If you're looking for advice, don't close it. Apply for your TPS, apply for a travel document, but don't close your asylum case, because the moment you try closing the asylum case, it raises questions as to why you first applied for it. Now they want to see the validity of that claim. So that's a dangerous move. Unless you have received a permanent green card somewhere, then you can close your asylum case. And even then, you just have to be careful of how you're closing it. So no, that's a no. Just go ahead and apply for your TPS on the side and your travel document, but don't close your asylum case. It does really raise a lot of questions, and then no, just don't do it. It's gonna put you in a lot of trouble for nothing, because you're gonna have to explain to them why you filed asylum at the first place. If my father filed for me while living in the US, you are 18. If you're over 21, it's gonna take like 10 years. But if you're 18, so you're pretty much under 21, it might take like 18 months. I'll win. That's the answer. So that's it. That's it, folks. Talk to you tomorrow. Bye-bye.